Ghanatube sunye and sama ekoso ewo on my name aha and I was ebekani na model snowy my science atanase there is some echo eba ede ebra sane matanase die na wo se kwa koje ensem no ede aba abusiafo ye ba na matwaso amo.
Legal arguments from lawyers for the suspended Chief Justice and also the Deputy Attorney General, Dr. Justice Shremsai, who represented the state, as in Ghana, in this case. A colleague, Dennis Pabewadam, he monitored the proceedings in the ECOWAS court, which we got to see part of it on online, as a matter of fact, earlier today. He's joining me in the studio. Dennis, good to have you. Thank you so much, as always.
Always a pleasure being here, Alfred.
Fantastic. What did we monitor earlier today? How did it play out on day one at the ECOWAS court?
Well, so basically today was for the hearing of what in our terms may be deemed as interim measures or interim reliefs that have been sought by the suspended Chief Justice. To put things in proper context, just like the way we have it in our courts here, where when a writ of summons, for instance, is filed, then subsequent to that, a party decides to file an injunction application to say that, okay, before the substantive matter is heard, let's put the process on hold until the matters are determined before anything else. So to liken that to what's happening at the ECOWAS court, we did indicate that the Chief Justice is before the ECOWAS court, seeking reliefs and making allegations of violations of fundamental human rights, right to fair hearing, and all that. But subsequent to that, she's brought another process in which she's seeking that in the interim, some reliefs be granted her while the substantive matter is being heard or determined. But let's rewind a bit. In the substantive matter, what really is she looking at? So in the substantive case, which is before the ECOWAS court, she's seeking for reliefs that the Republic of Ghana lifts the suspension and restore the Chief Justice to office. We do know that she's now under suspension, and that's because of the impeachment process that she's going through. She says that that suspension, in her view, is not supported by law, and that the manner in which it has been done is unlawful, part of the reasons that she's at the ECOWAS court. She is also seeking that a declaration that the suspension itself violates her human rights, specifically right to fair hearing. She argues that point very strongly, even in local courts, to suggest that even as we speak, she has not been properly served the determination of the prima facie case and even the petitions themselves in question. So all those matters are still reliefs that she's looking at before the ECOWAS court. She's also asking for a declaration that the panel that instituted the investigation allegations of misconduct was not constituted to guarantee its independence. She has an issue with the panel in its entirety, and she's seeking a relief in that regard.
This is consistent with what she's been talking about all the while, is it not? About certain persons on the 5-member committee whom she believes have already been compromised because of their position in previous cases, and so on. That's not new, is it?
Precisely so, because in substance, the case that is before the ECOWAS court is not, and I emphasize, substantially different from what she has before the local courts. And local courts have been the matter before the Supreme Court and also the matter before the High Court by way of judicial review. Substantially, the net effect, if it goes through, will come to a same conclusion, that i.e., what she's going through, it's a violation of her fundamental human rights. It ought not to have happened, and that the procedure that is being used is not that which is spelled out in the law. So, like, you're right on that particular score. But then again, in this particular matter, she's seeking an additional relief that is by way of an award of $10 million as compensation for what she says is the moral and reputational damages that she suffered as a result of the suspension. So these are matters that the ECOWAS court will deal with in the substantive matter. This is not the matter that was dealt with today, because this matter is still pending. It will be dealt with. So what they dealt with today is to the effect that, okay, even while we look at determining this matter, there are some things that need to be done now, so that while we are working with this one, those things will not be overtaken by whatever the outcome of this would be.
I see.
So let's look at those ones. Now, She's asking that there should be a suspension of the disciplinary or removal process against her pending the hearing and determination of the case. So like I did explain earlier, when she filed the writ of summons before the Supreme Court, subsequent to that there was a filing of an application, an injunction application, which sought to halt the process.
True.
Now, this interim measure, which is being sought at the ECOWAS court, one of the reliefs she's seeking by way of an interim measure, or what they call a precautionary measure, is that there should be a suspension of the process that she's going through now. That is the disciplinary or the removal process against her, pending the determination of the substantive matter.
So that she'll still come back to occupy the office of Chief Justice? Well,
if the suspension is removed, then it means that she comes back to where she was before the suspension.
I see.
She's also asking that she continues to enjoy the paraphernalia and entitlements Chief Justice's office of the Chief Justice's office, pending the hearing and determination of the case. That is to say, now that she's under suspension, she is unable to enjoy some entitlements that she would have enjoyed if she were in the position of a Chief Justice.
Right.
And for that reason, she wants that in the interim, a relief be granted that she continues to enjoy those entitlements and paraphernalia. She continues to ask for another relief in the interim, that the Republic of Ghana refrains from taking any other measures that may harm the rights claimed by the Chief Justice. That is to say, Ghana should refrain from doing anything that will stop her from enjoying the rights that she claims, if she eventually gets them. So these were the matters that the arguments were made in respect of today for the court to decide whether they should be granted in the interim while they look at the substantive matter or not.
Right.
Now she has argued, and basically all that she's been saying, the effect is that it is an abuse of her fundamental human rights. Right to fair hearing, right to employment, and all that. Now the Attorney General does not think that these interim measures should be granted her.
Why is he saying so?
Now, one, as part of his arguments, he says that Her Lady the Chief Justice is still the Chief Justice of Ghana. Mind you, one of the interim reliefs is to the fact that she should be reinstated. Then the argument that the Attorney General is making is that she already is the Chief Justice.
On suspension.
Even though she's suspended, she is still the Chief Justice. The other argument that is being made by the Attorney General is that the Chief Justice, in this case, Her Lady Chief Justice Torkornoo, has no personal right to continuous performance of the functions of the office of the Chief Justice, where she is subject to a constitutionally prescribed removal proceedings. So that is to say, yes, you are still the Chief Justice, but when it comes to the performance of your functions, there are instances where you are not allowed to perform those functions. And one of such instances is where you are undergoing a process which has been prescribed by the Constitution. The Attorney General goes on to say that the suspension of the Chief Justice from office was not done unilaterally or arbitrarily. And this is in response to the arguments by lawyers for the suspended Chief Justice to the effect that the suspension was not done in line with law.
Yes.
Now, the Attorney General explains that it goes through a process prescribed under Article 146, and that they have gone through that process to suspend the Chief Justice, which includes the consultation with the Council of State, and that it cannot be that this suspension was unilaterally done, as has been alleged by lawyers for the suspended Chief Justice. The other argument that is made is that the suspension of the Chief Justice from office was done strictly in accordance with the provisions of Ghana's Constitution. That ties in with the earlier point. Right. That is to suggest that the fact that the President didn't do it unilaterally, the procedure that was adopted in doing it is one that has been spelled out in the Constitution. Specific reference to Article 146 of the 1992 Constitution. They also go on to argue that the suspension pending the outcome of the removal process does not occasion a serious or irreparable damage. This typically will be the kind of argument that one will advance if it were in the local courts for the grant of an injunction, and in that instance for the grant of an interim measure. So the Attorney General is simply making the case that yes, this that she's asking for, it will not occasion an irreparable damage if we continue to hear the case while the process is still ongoing. So for that matter, the interim measures should not be granted. And that's the substantive application, that is what we have looked at, is manifestly inadmissible. They go on to make an argument as to how the ECOWAS court itself has given decisions to the effect that where local courts have pronounced on certain matters, it is not for those courts to review same.
Right.
So they argue on that line to say that it is manifestly inadmissible. And directly connected to that is the argument that the court is incompetent to assume jurisdiction over the substantive suit, relying on the same explanation as I've already indicated.
If you say the court is incompetent, essentially they are questioning the powers of the ECOWAS court?
Precisely so.
To hear this?
To hear this matter, because the court itself has made determinations in other matters that when it comes to issues of where local courts have made a determination, it is not for that court to seek to review same. And this is where they cite instances of how the matters, at least the 5 injunction applications, have come before the Supreme Court and have been dismissed, and that there are also other pending matters that are still before the local courts. And that's how come this argument was made. And also that the substantive application does not disclose any chance of success. Yes, of course, it's one of the things that you argued for the grant of an injunction. That is to say, the matter that you want them to stay, the substantive suit should be one that has a chance of succeeding. If not, imagine they stay a process and at the end of the day, you don't succeed in it. It will be a waste of everybody's time. So the Attorney General's argument is simply that the substantive application does not disclose any chance of success. And then again, they indicate that at least in 5 attempts to get the result that is being sought here failed. So in their view, they do not think that it is one that should be granted. So essentially, that's how the arguments went today, and the court decided to adjourn, not to any specific dates, and that adjournment is for the court to now come and make a determination on the interim measures. Then before they progress to hear the substantive suit itself.
Great detail there, Dennis. But stay with me, and let's flip back to Jean, okay? And then also we'll touch on the $10 million that the suspended Chief Justice is asking for, the specific context in which she's asking for that amount from the state. But the G is essentially questioning the jurisdiction or the power of this ECOWAS court to hear this case. And this is where I bring in Kweku Ansah. He spoke to us earlier, indicating his position on whether or not the ECOWAS court has the jurisdiction to hear this case and whether the suspended Chief Justice has exhausted the internal mechanisms of redress before taking her matter to the ECOWAS court. And Kweku Ansah is a former director of the Ghana School of Law. He is also a private practitioner, a legal practitioner, and also the owner of Mount Crest School of Law, essentially. But let's hear from him on this matter of the jurisdiction of the ECOWAS court to hear this case. What's the contention in there?
Well, she exhausting internal remedies simply means ensuring that the proceedings have terminated to completion. They have, gone through every step. You see, she is preventing the steps from being implemented. So she hasn't exhausted. She cannot be said or cannot be argued that she has thereby exhausted, the internal remedies. No. So merely, inundating the court with, incessant applications is no meaningful reason to suggest that she has, exhausted the internal remedies. She has been filing application upon application, and if you look at the nature of the application that have so far been judicially considered by the High Court and the Supreme Court, you see that they were wholly, factually, and legally unmeritorious. And if an application is without any merit, the obvious outcome is a dismissal. It will be refused, and they have been refused. And when she launched the first one, you recall that on one of your shows, I indicated that she can file millions of applications, but insofar as Article 146 is concerned, the provisions stand guard over any such application. So you may file repeated applications. They can only create ugly noises in the courtroom, but applications ultimately become a social nuisance. Legally, they are incompetent, and for a Chief Justice, bringing application upon application and being told to their face that the applications lack merit is not good for her own image. It is not good, for the general public. It is not good for Ghana as a nation. That our Chief Justice will file an application that a committee, will assess, evaluate, and say it's incompetent.
I see. And that's the concern side. And I'm going to come back on how he sees this case playing out, because it has been adjourned to a date yet to be determined, and then we'll get into the details of it. But one of the issues that stuck out when this matter became public earlier today is the suspended Chief Justice's demand of $10 million compensation. In what context exactly is he asking for that? Why is he asking for this money?
Well, so that is one of the reliefs that she's seeking under the substantive case. And she's seeking that amount as compensation for what she says it's an illegal suspension and investigation. So what she's basically saying that for all that you have taken me through, in my view, it is illegal. So in order to make up, at least, for what you have taken me through, which ought not to have happened, I deserve an amount of $10 million to be able to restore me to wherever I was. And that's the context in which she puts it. It's one of the reliefs she's seeking under the substantive matter.
So just a compensation for moral and reputational damages.
Yes, suffered as a result of. So when you look at the exact text, she refers to the suspension as illegal, and then she adds investigation to it. So essentially, what she's saying is that this is how much it will take to compensate me for what you have taken me through, which in my view, it's illegal. So if the court reaches the conclusion that indeed what she's been taken through is illegal and agrees with her that this is how much she would require to be compensated enough, then well, bingo.
$10 million.
Yes.
I see. Well, because I mean, how does he see this case playing out at the ECOWAS court? That's another question that we sought an answer from him on. This is what he had to say.
Oh, it's one of those, cases, I think, that be a return match. They will ask her, they'll bounce her to come back to Ghana. I don't see how the ECOWAS court can change our rules of procedure. Our rules of procedure are, firmly embedded in the High Court rules with the support of, the Evidence Act of 1975 and RCD 323. They are there. It is a procedure for, Ghana. It is not the procedure for ECOWAS. It's for Ghana. And ECOWAS doesn't have, a West African sub-regional procedure that we are applying and violating. It is our own rules of procedure and evidence that we are applying. And therefore, taking the matter out of the purview of our court to the ECOWAS court is not going to achieve the desired, purpose. I think it will be defeated. And at the end of the day, I think that upon a sober reflection, the Chief Justice will realize that, she has shot herself wrongly in the foot. No one else. She's making her bed and she's lying in it. And it saddens and pains me that, she's adding more insult to injury. I've said elsewhere that she is not respecting the constitutional arrangements pertaining to the CJ removal process outlined in Article 146. She has to respect and uphold the very laws that are administered in the courts over which she is the chief judge.
So we'll see how this case will play out at the ECOWAS court, but Dennis Wadam Esquire giving us that very important breakdown and the details, so we all follow every step of the way how things played out in court. That's the ECOWAS court earlier today. Very interesting detail, and stay with us here on Ghana Tonight, because the coming days.
Yeah, kwaje ensem no about with major comment comment section down major brain na makenkan ni na down modofo snowy and abetina say ensem no ebrem Ghanatube so sisi ade makram.